Cool. Continue to look. Okay. So a broker loses her license and there is no licensed broker to take over the broker's business. In this case, is it A, the probate court must approve the appointment of the ancillary trustee? B, the sales agent may take over only those listings that are in contract? C, the sales agent may take over the listings? Or D, an ancillary trustee may be appointed by the superintendent to conclude the broker's business? Okay, so we got D. And D is correct. Good job. So yes, so the probate court is only when like death is involved. So it would be D. Gosh, I'm learning so much by just doing these practice tests. Okay, next question. A homeowner is selling his house without the aid of a broker. The homeowner advertises that he will give anyone who buys his home 2 free airline tickets to anywhere in the continental United States. What is true? Is it A, a seller is not authorized to give an inducement of any manner to the unrepresented buyer? B, this inducement is a violation of Ohio Revised Code licensing law. C, this inducement must be disclosed on the sales contract. Or D, this is perfectly legitimate and does not need to be disclosed on the sales contract. Yeah, and everyone feel free to put their answers in the chat. The more answers, the better. These are tough questions, so never worry about getting them wrong. All right, let's do D. And D is correct. So this is perfectly legitimate and does not need to be disclosed on the sales contract, which is super tricky because it does sound like it's an inducement. Okay, next question. After recording an affidavit of lien with the recorder's office, the broker shall provide a copy of the lien affidavit in parentheses where a contract for sale or other conveyance of the lien property has been entered into to the A, prospect of the transferee, B, owner of the lien property and the prospective transferee, C, owner of the lien property, or D, superintendent. Copy the question, paste it in the chat. Oh, anytime I click Command Control C to copy, it automatically puts answer C, but feel free to put your responses in the chat. Okay, we got B. And B is correct. Good job. We're on a roll. Okay. No, and there's 20 questions in this, so solid amount of data this will cover. So what lien automatically attaches to a commercial property to secure a broker's commission? Is that A, an attachment lien, B, a broker lien, C, a judgment lien, or D, mechanics? Feel free to put your responses in the chat. So what lien automatically attaches to a commercial property to secure a broker's commission? Okay, we got a variety of answers. Majority A. And it is B. So under the broker lien law, a broker can attach a lien to a commercial property only. Oh, good to know. So the broker is the only one who can attach a lien to a commercial property. Sounds like a broker question, but they give you all on here. So a licensed property manager is negotiating a lease on behalf of a commercial landlord. The property to be rented is retail space in a soon to open mall. What type of lease would you expect the property manager to negotiate? Is that A, land lease, B, a percentage lease, C, a net lease, or D, a gross lease? Question. All right, we got B, percentage lease. That is correct. Good job. So the percentage lease is usually used in retail establishments with the rent based upon a percentage of the sales that the tenant makes each month. Next question. What would a license be considered in when would a license be considered inactive? Is that A, when the broker dies, B, when the salesperson fails to turn in proof of CE, C, when the salesperson does not have a transaction within the mandated period of time, or D, when the salesperson directs the broker to return the license to the division? When would a license be considered inactive? So there's like a few answers in here, but there's one that's the better answer. Again, feel free to drop it in the chat. Yeah, that's right. I also I also think I was thinking either D or B, but let's see. Yeah, D is correct. Good job. So an inactive license is a voluntary status that is initiated by the salesperson of a broker. Failure to turn in proof of CE may result in license being suspended. Got it. So your license goes inactive when you tell the brokerage to send it back to the state, but then your license becomes suspended when you don't complete the necessary like CE credits or that post licensing, 20 hours of post licensing. Got it. All right, good job. A buyer makes an offer on a property. The seller issues a counteroffer, which the buyer signed and the selling agent delivered to the listing agent. The buyer passes a FSBO and likes it better. He makes an offer to the FSBO and the seller accepts. Which of the following is true? And FSBO is going to be a for sale by owner. Is that A, neither contract is enforceable? B, the contract on the first house is not enforceable? C, only the first contract is valid? Or D, both contracts are valid? All right, we got D, both contracts are valid. That is correct. So basically, the buyer just purchased two properties. Whoa. All right. An agent wishes to specialize in the sales of commercial property. What should they do? Choose best answer. Is that A, seek additional education in order to be licensed to sell commercial property? B, find a broker that specializes in the sales of commercial property? C, stay with the same brokerage? Or D, must have done at least 20 residential transactions to sell commercial property? So an agent wishes to specialize in the sales of commercial property. What should they do? No, this is a question I actually get often. All right, we got B. So the correct answer is C. It does sound like B would be the best answer, but Ohio license law says there is no distinction between residential and commercial real estate from a licensing standpoint, and an agent can continue to stay at their same brokerage and sell commercial as well as residential. So it's cool because you could just also sell commercial with having a residential salesperson's license. You don't need a specific license to sell commercial, but it is always good to obviously work within a brokerage that has commercial as an opportunity. And funny thing is, so we actually did just recently start a commercial branch, and we have an agent that specializes in commercial properties only. So if you guys ever have a deal, then you can work with him, and then he'll give you like all the ins and outs since he's literally only specializing in commercial these days. All right. Next question. Homosexuality is protected under what federally protected class? Is that A, homosexuality is not protected under any federally protected class, B, sex, C, national origin, or D, familial status? A, and A is correct. So homosexuality is not protected under a federal protected class. Definitely knowing what acts protect what is very helpful. How many hours of continuing education are required by an Ohio licensee over a 3-year reporting period? Is that A, 35, B, 30, C, 26, D, 20? B, 30, and that is correct. So you do need 30 continuing education over every 3 years. And there are 9 hours, like 3 are civil rights hours that you need, 3 are law hours, and the third one is, I believe, maybe has to do with appraisal. But yeah, good job. And then the 20 hours is that what you have to complete within the year, the first year of being licensed. Okay, so if a broker dies and there are no other brokers in the firm, what is true? The Ohio Real Estate Commission may appoint an ancillary trustee. The Department of Commerce will appoint an ancillary trustee. The superintendent may appoint an ancillary trustee with the approval of probate court. Or D, any salesperson associated with the firm may take over the deceased broker's listing. So if a broker dies and there are no other brokers in the firm, what is true? Correct. So it is C. So what's super helpful to know about probate court, any case that has to do with a death, probate, any answer that has probate in it is most likely the best answer. Good job. If the superintendent pays any amount from the recovery fund in settlement of a claim toward the satisfaction of a judgment against a licensed broker or salesperson, is it A, the license of the broker or salesperson is automatically suspended? B, there is no action against the broker or salesperson as the fund is set up to protect the public? C, the license of the broker or salesperson is automatically revoked? Or D, the salesperson or broker must pay a fine of $2,500? A? And A is correct. Good job. This was a tough one. So the license of the broker or salesperson is automatically suspended. Next question. Who administers the real estate license law? Is that A, real estate commission, B, the police, C, division of real estate, or D, Department of Commerce? All right. So we can, let's see, we have A and C. So the correct answer is C. So the Division of Real Estate administers the license law. The Real Estate Commission, Division of Real Estate, Department of Commerce are all confusing at what they do, but definitely making a little chart as to what each of their main responsibilities are is very helpful. And I can't even remember what their main responsibilities are. Okay, next question. Under Ohio law, a non-licensed employee of a property manager may A, negotiate a lease between a landlord and a potential tenant. B, accept payments of pre-negotiated rent from the tenant each month. C, explain the difference between a periodic tenancy and a month-to-month tenancy. Or D, prepare the lease for the landlord and tenant. So under Ohio law, a non-licensed employee of a property manager may do what? Okay, we got B. And that is correct. So a non-licensed employee of a property manager may accept payments of pre-negotiated rent from a tenant each month. Good job. Okay, next question. When must a broker record a written release or satisfaction of broker lien in the county recorder's office in which the lien was recorded? Is that A, within 15 days after the owner satisfies the claim? B, within 90 days after the owner satisfies the claim? C, within 10 days after the owner satisfies the claim? Or D, the owner must file the release of lien after the claim has been satisfied? And I thought I chose a quiet spot outside. I was wrong. Okay, this is a tough one. Let's see. So the correct answer is C. It's in within 10 days after the owner satisfies the claim is when we have to record, when the broker has to record the lien in the county's recorder's office. Okay, next question. What would you expect an Ohio property manager to do? A, prepare a land contract in case the landlord wanted to sell the property to a tenant. B, convert the apartments into condominiums for the landlord. C, initiate actions for the recovery of rent. Or D, prepare lease agreements of tenants to sign. Oh, I got C, and C is correct. So initiate actions for recovery of rent. So any question that says like prepare a lease or prepare a contract will be definitely somebody who practices law. So that will never be the correct answer. If it has to do with property manager or an agent, it's anyone has who practices law is able to prepare leases and prepare contracts. We explain them and we use them, but we don't prepare them. Okay, so upon the death of a licensed broker, what might occur? A bro a broker within the business entity of the deceased broker takes over the listing. B, the superintendent appoints an ancillary trustee. C, the sales agent takes over the broker's listing. Or D, the Ohio Real Estate Commission appoints an ancillary trustee. Or wait, we got A. And A is correct. So if a broker dies and there's another broker in the business entity, then the broker may take over the listings without the appointment of an ancillary trustee. Good job. Okay, next question. A sales agent in his advertisement, a sales agent in his advertisements that he will provide a free room addition to anyone who buys one of his listings. What is true? A, this is legal as long as this is noted on the sales contract. B, this is unethical and the sales agent is not allowed to offer an improvement in real estate as an inducement. C, this is legal as long as the inducement is disclosed between the buyer and seller. Or D, this is unethical as sales agent may not offer anything as an inducement. All right, we got A. A is correct. This is legal as long as noted on the sales contract. Good job. And then obviously you need the buyer and seller to sign the sales contract. And so if they both agree, so the meeting of the minds, then it is legal. Okay, so a broker offers a seller a free trip to Hawaii in return for a property listing. What is true? The buyer and seller must agree to this inducement. The broker must disclose this on the listing contract. The broker must disclose this to the potential buyer. Or D, the broker must disclose this in the real estate sales contract. All right, we got B. And B is correct. Good job. This is kind of tough. So yes, so the broker must disclose this on the listing contract. Good job. All right, next question. Broker X is managing a client's 5-unit apartment complex. The broker receives rent deposits of $100 for each unit. What must a broker do with the rent deposit receipt? Is that A, deposit them in the broker's trust account, B, deposit them in the office management account. C, deposit them in the property management account in the client's name. Or D, commingle the funds with trust account. All right, we got C. C is correct. Good job. So deposit them in the property management account in the client's name. Going to be the best answer. Okay, good job, guys. Oh, we crushed this one. Okay, next section. Feel free to put in the chat what topic you want to go over. Here are the various topics. All right, financing. Cool. Michelle too. All right. If a lender is charging a borrower an interest rate of 5% and also charging the borrower 2 points, what is the lender's yield? Is that A, 7.25%, B, 10%, C, 5.25%, or D, 7%? So if a lender is charging a borrower an interest rate of 5% and also charging the borrower 2 points, what is the lender's yield? So once you know how to do this once, you'll know this every time moving forward. So 2 points equals how many percent? Actually, so the correct answer is 5.25%. So the lender's yield is the rate of interest plus 2 points. So 2 points would be 5.25%. And well, this is how you calculate that. Don't get hung up too much on this because there may be 1 or 2 questions on it, if that. Again, with the real estate calculations, don't get hung up on it. Just kind of have an idea of where you would divide or where you would multiply, but there won't be too many questions on there. Okay, so next question. The seizing of property by court order as security for a debt or judgment is known as A, alienation, B, capitalization, C, encumbrance, or D, attachment. All right, we got A. Oh, this is a tough one, but so the correct answer is going to be D. So the seizing of property by court order is attachment. Usually the property is attached to be sold at public auction to satisfy a judgment. And then alienation is transferring an interest in real property. And then encumbrance is a burden on a person's title. And then capitalization is the calculation of value according to the income and rate of return. Okay, good job. Next question. A mortgage is recorded to A, create a valid lien, B, comply with truth in lending regulations, C, transfer title to the mortgagee, or D, assure amortization payment. And yeah, good job. So it is create a valid lien. So a mortgage is recorded to create a valid lien. Good job. So having a mortgage is like having a mortgage is a lien on a property. Okay. Next, the obligation or promise to be personally liable for conditions in another person's contract is known as A, assumption, B, assignment, C, novation, or D, ostensible liability. So the obligation or promise to be personally liable for conditions in another person's contract is known as what? That novation? So would be assumption. Yeah, this is a tough one. So the giving of one person's contract rights to another is assignment. And then the promise to be liable for another person's obligations under contract is assumption. So that person assumes the responsibility. Well, assignment is without release of liability. Novation does release a withdrawing party from the liability under the contract. So novation was also a very good answer. All right. That was a tough one. Cannot remember what novation was. Okay, next question. A blanket mortgage involves what? A, a single loan with two or more parcels of property offered as security. B, a loan with a balloon payment at the end. C, a fully amortized mortgage. Or D, two loans combined into one interest rate. All right. A. A does sound good. And at the end, I don't think it's either A or D. Let's see. Maybe I'm wrong. Good job. So it is A. So good work. A single loan with two or more parcels of property offered as security. Good job. So a blanket mortgage is a single loan with two or more parcels offered as security for a loan. Then you have a wraparound mortgage, which is two separate mortgages are wrapped into one and combined at a new interest rate. And then you have a balloon payment is paid at the end of the loan term to pay off the entire remaining balance of the principal and interest not covered by payments during the loan term. And then a fully amortized mortgage involves payments that are applied to both interest and principal. This is a very helpful explanation here. Okay, good job. Next question. Both the mortgage deed and the mortgage note are signed by the borrower, the note is A, not recorded, B, not really necessary, C, signed in duplicate with a copy for each of the buyer and the bank, or D, retained by the borrower as a reminder of its maturity date. Gosh, they love always throwing in some confusing answers. Uh, Did I already copy this? Oh, cool. It does give you the answer. So the correct answer is not recorded. And so a mortgage deed is recorded and the the mortgage deed is recorded to create the lien on the property. And then the mortgage note is as a personal promissory note that is retained by the bank. It is not signed in duplicate as it would create two debts, which could both be told by the bank. So yeah, they try to confuse you in here, but the note is the promissory note. So the mortgage note and promissory note are the same thing, and that's retained by the bank. But is not duplicated, so that's why it's confusing there. And then the note is not recorded, but the deed is. Okay, good job. A lump sum payment of principal is due at the end of which type of promissory note? Is that A, major, B, fully amortized, C, balloon, or D, wraparound? Right, we got balloon, and that is correct. A balloon mortgage is one with a lump sum payment of principal due at the end. Good job. Gosh, I was hoping that I had only questions about the balloon mortgage on my exam because that's the only one I could like completely remember. I don't think I did. It's definitely helpful to know the difference between all of the various um, types of mortgage and how payment works. When you're an agent, this is all for the loan officer to explain to your client. Okay, next question. The taking of another person's rights and obligations in a pre-existing contract is known as A, novation, B, assumption, C, ostensible liability, or D, assignment. We have an answer. Correct. Assumption involves the taking or receiving of another person's rights. Assignment is giving a person's rights and interests under contract to somebody else. And then a broker, for example, has what is known as ostensible liability. The broker is always liable for any discrimination by their agent, whether or not the broker knows about the discriminatory act. And then novation does not release a withdrawing party from liability under a contract. Okay. Property is attached in order to A, provide security for payment of a debt or judgment, B, compute cost replacement value, C, compute valuation for mortgage loan purposes, or D, construct zoning boundary line. So property is attached in order to what? All right, D was a good guess. So correct answer is provide security for payment of a debt or judgment. Attachment is the court-ordered seizure of property to provide security for a payment of debt. Okay, next question. A partially amortized note that reduces part of the principal by the time the final payment is due is often called A, wraparound mortgage, B, fully amortized loan, C, conventional loan, or D, balloon payment balloon note. So partially amortized note that reduces part of the principal by the time the final payment is due is often called what? Okay, so this is a balloon payment or balloon note. This one's confusing because that's like at the end of the loan. So they didn't really explain this properly. So this is kind of a poorly worded question. But the balloon payment, balloon note is a partially amortized with a lump sum payment of the principal due at the end of the loan. So when you think of balloon payment, partially amortized and is also a lump sum payment of the principal due at the end of the loan. Okay. Financing is always a tough topic. Cool. Okay. Any recommendations on next subject that we want to go over? Feel free to put in the chat. I'm trying to think of what ones we haven't done. Chat. The license law? Okay. We can do the license law again. Sounds good. Okay, so a person making application to the recovery fund for payment must file an application to recover within A, 90 days after the termination of all court proceedings. B, 60 days after the termination of all court proceedings. C, there is no statute of limitations on a claim against the recovery fund. Or D, 1 year after termination of all court proceedings. Okay, we could hustle through these. Laptop might, no, I think I should be good. Okay. Hmm. So the correct answer is 1 year after termination of all court proceedings. Oh, so hopefully you guys, a lot of you are taking the Ohio one because these are hard, but definitely will help with the exam. Okay, next question. Although not mandated by statute, the Ohio Division of Real Estate recommends that for the purposes of document handling and record keeping, A, all agents should have ready access to all files. B, the agent who works on the file should have access to the file. C, all files be listed on the internet for public access. Or D, a non-licensed clerical employee could have control of all files. All right, and the correct answer is B, a non-licensed clerical employee should have control of all files, which is shocking, but these files should be kept under lock and key. You would think that would be a licensed person, but it's a non-licensed. And it's not regulated by the state by any means. What is the maximum number of do business as DBA names a broker is allowed to operate under? No more than 3, only 1, no more than 2, no more than 5. So it'd be no more than 5. A broker can have up to 5 business names to do business as. Oh, I actually did not know that. That's crazy. So they can work under 5 business names. Okay. Next question. Under the Ohio Real Estate Recovery Fund, the commission shall impose a special fee not to exceed $10 annually on each license filing a notice of renewal if the recovery fund is less than 3 million, less than 2 million, less than the commission may impose the $10 at any time, or less than $500,000. This is a good one. Any guesses? Remember. Okay, so it is 500,000. So impose a special fee not to exceed $10 annually. and this is less than 500,000. No need to know like section 473.10 or 473.14. You won't need to know those things. So if given the choice, what type of a listing agreement would a seller probably prefer? Is that A, open listing, B, exclusive right to sell, C, net listing, or D, exclusive agency agreement? So it would be an exclusive agency agreement. So an exclusive agency agreement is when the state, if the seller finds the buyer, the seller saves the commission. All right, let's do five more questions. Buyers make an offer to purchase and to place 1,000 in earnest money into the broker's trust account. The sellers want the earnest money check made payable to them instead. The sales agent should A, ignore the seller's request as this is illegal and the sales agent does not have to follow an illegal request. B, write a counteroffer stipulating the seller's request. C, not present the offer to the sellers. Or D, tell the sellers that the sales agent may accept a check made payable to the brokers only. Which one are we thinking? The correct answer is B, write a counter offer stipulating the seller's request. So the sales agent is the only person to whom the earnest money check may be payable. Other than that, the earnest money is handled according to the agreement of the parties. Next question. Who does an agent need to notify for a change of his or her home address? Is that A, their broker, B, the Division of Real Estate, C, the commission, or D, the local board of realtors? So who does an agent need to notify for a change of his or her home address? All these people could be helpful, but there's a specific person or group. The correct answer is the Division of Real Estate. They handled all motion of licensee, including transfers and status changes. So that is who you would tell if you change your home address. And obviously, you would hope you tell your broker too. Okay, next question. For a minimum of how many years must a broker keep records? Is that A1, B3, C5, or D2? So it is 3. Under Ohio Revised Code, a broker must keep a copy of all transactions for a minimum of 3 years. So 3 years is key of the transaction. Good job. Okay. Okay, we have time for two more questions. Next question. Which of the following is not a management level licensee? A team leader, B, a new salesperson, C, an associate broker, or D, a salaried licensed office manager. So which is not a management level licensee? B is correct, a new salesperson. All right, good job. Okay, so the principal broker has the following duties except A, prepare listing agreements, B, oversee the direct operations, C, comply with office requirements, or D, comply with fair housing documentation requirements. Correct, good job. So again, that would be prepared by an attorney. Good work. Okay, I can do two more, and then I think my computer's gonna die. Okay, so A, the principal broker has the following duties except A, oversee the direct operations, B, comply with the office requirements, C, comply with fair housing documentation requirements, or D, prepare a listing agreement. Okay, good job. That is correct. Next question. Oh gosh, of course. A buyer is going to make an offer on a seller's home. The listing agent asks the buyer for $1,000 in earnest money. The buyer does not want to give $1,000 in earnest money, but the listing agent says that this is state law. What is true? The buyer must give the $1,000 earnest money. B, the listing agent is wrong. There is no state requirement requiring a minimum or maximum amount of earnest money. C, earnest money is set by federal law. D, earnest money is set by state. Correct. You can put $0 for earnest money if you wanted, as long as the other party agrees. So meeting of the mind. Okay. A broker receives an earnest money payment. The broker deposits the earnest money in his trust account. By law, what is the amount of interest a broker may bear on the trust account? Is that A, 10%, B, 4%, the minimum required by state first rate laws, or 0%? All right, we got D. D D is correct. The broker is not allowed to bear any interest on the trust account. Good job. Okay. A broker receives a client's earnest money check and deposits into his trust account. Prior to the closing, however, the broker needs money to pay monthly overhead expenses. He borrows some money from the trust account, fully intending to replace it before closing. The broker is guilty of what? Misrepresentation, commingling, condemnation, conversion. The correct answer is conversion. Conversion is a theft of converting funds in for personal use, and then commingling is mixing trust funds with personal funds. Okay. So what protected group is under the Ohio Civil Rights but not under the federal civil rights law? And it is ancestry. So under the Ohio Civil Rights law, but not under the federal civil rights law is ancestry. So which of the following grants the broker the exclusive right to represent the purchaser in the purchase of a lease property? Is that A, agency disclosure statement, B, exclusive purchaser agency agreement, C, buyer listing agreement, or D, consumer guide relationships? Sorry, I'm buzzing through these. And that is going to be exclusive purchaser agency agreement. So if a broker is hired by a buyer, the buyer will be obligated to pay the broker who has the exclusive right to represent the buyer if the seller does not offer compensation. It's called the exclusive purchaser agreement or exclusive buyer's agreement. They're very similar. Okay, next question. Which of the following is a violation of license law? Is that A, having acted as a broker without authority impeded the ability of the principal broker to perform any of the duties or impede the ability of management level licensee to perform the license duties? B, hire other salesperson from different brokerages? C, offer a free CMA to a landowner? Or D, offering training to a pre-licensed agent? So it would be A, which is just a very complex answer, but definitely not okay and a violation of law. Okay. From where does the real estate licensee get the 19 articles of canons of ethics? Okay, I don't even know. Is that A, the Real Estate Commission, B, the Ohio Association of Realtors, C, the Division of Real Estate, or D, the National Association of Realtors? I want to say it's the National Association of Realtors, but I don't know. Okay, so the correct answer is going to be A. So from what does the real estate licensee get the 19 articles of canons of ethics? It's going to be the Ohio Real Estate Commission. Okay, next question. A buyer makes an offer to buy a home and faxes the offer to the seller in another state. The seller, upon receipt, signs the offer, intending to mail it back to the buyer the next morning. In the meantime, the buyer telephones the seller and withdraws the offer. What is true? There is no contract as the acceptance has not been delivered to the buyer. Both parties are now bound to the terms of the contract. There is a contract as the seller has accepted the buyer's offer. There was never a rightful offer as the offer was faxed and the seller must have received the original offer. So it will be A. There is no contract as the acceptance has not been delivered back to the buyer. So he is allowed to withdraw because he never knew that the seller even accepted. Okay, so a buyer makes an offer to purchase a house and gives the seller until midnight, 3 days, 10, to accept the offer. Prior to the acceptance, the buyer withdraws the offer. What is true? So similar to the last question, the buyer is allowed to withdraw the offer anytime prior to acceptance. The buyer may not withdraw the offer. There is a contract. Since the buyer made an offer, the buyer must wait until the end of 3 days to withdraw the offer. And it is A. Keep in mind that there was not a contract since the acceptance of the seller had not been made. This was an offer which can be withdrawn anytime as acceptance. Okay, thank you everyone for attending. I promise next week I won't have distractions in the background. And good luck to everybody on your exams.